First, we'd like to introduce John Agioritis. John provides trusted advice and counsel to corporate clients navigating various types of emergencies, crisis, and incident response, including workplace safety incidents and environmental matters. John is also an experienced litigator who represents corporations and entities of all sizes in sensitive, complex, high-stakes regulatory investigations, trials, and appeals. He also provides proactive advice on compliance programs and due diligence measures designed to meet or exceed regulatory obligations. Lovely to have you here, John. I'll let you take it over.
Appreciate it. Thank you very much for the opportunity, everybody. I really appreciate being here. It's an honor to be able to share some learnings with you. Safety can certainly be rewarding. It can be very hard and challenging as well. And you know, one just needs to take a look at the story that was playing before we got into the session here with the Carmont construction case and Rebecca Shenstead. That's a tragic situation that can impact a number of lives, but there are also a number of lessons that come out of a story like that. And so hopefully you get some information from this legal trend session that will give you that type of background and context. Undoubtedly, I am employer's counsel, so I come at this with an employer's perspective. I know that there are members of industry here. There are probably some regulators or other members who may be present as well. So what I say is directed towards employers generally. So with that, let's begin. I do want to give a land acknowledgement first. We acknowledge that our offices are located on the territories of Indigenous peoples who have occupied the land since time immemorial, including the First Nations of Treaty 1, Winnipeg, Treaty 4, Regina, Treaty 6, Edmonton and Saskatoon, Treaty 7, Calgary, and the Coast Salish peoples in Vancouver, as well as other non-treaty First Nations and Métis. We benefit from the lands, and we are dedicated to ensuring that the spirit of reconciliation is honored and respected. So on the agenda today, I was asked to speak, and I had spoken to your group last year, and again, was happy to do it. Last year's presentation focused on a component of criminal negligence, I think was the predominant aspect of it. This year, I'm going to take a bit of an approach relating to recent notable decisions in Saskatchewan. I am going to touch on some updates relating to criminal negligence, because I think that's a super important area. Plus, there have been developments for supervisory liability, not necessarily in this province, but in Alberta. And I think there are some good takeaways from those cases. And then, I mean, we're going to escalate the case, as Dallas indicated, and talk about ladder and scaffold safety. I have to tell you, that seems to be one of the interesting audit type areas that occupational health and safety inspectors are focusing on. And we've seen 3 cases dealing with that type of an issue. So I thought it important enough to mention it to you here in this session. So let's get into it and talk about the notable decisions. I think everyone by now has heard about the Sudbury decision, that matter in Sudbury, Ontario, where the city of Sudbury was on the work site. It was effectively the owner of the work site, and it engaged another contractor to perform service work relating to either underground piping or the underlying road area that was in place. Unfortunately, a pedestrian had crossed into the area and was contacted by a loader and was fatally injured as a result. And prior to that, the city had notified the contractor named Interpaving that there was some issues. The underlying matter was litigated. Interpaving ended up entering a plea of guilty, and the city of Sudbury had also been charged, but they had been charged as an employer. So here we have an owner who's effectively delegated what would be the equivalent of prime contractor responsibility to a contractor, thinking that, okay, by virtue of that delegation, I've offloaded a number of my legal responsibilities, but I'm still going to take an audit approach in this case. But the courts indicated that, the prosecution indicated that they were going to try and charge the city of Sudbury as an employer because they had workers that were on the work site doing that audit function. The Supreme Court of Canada ultimately allowed the charges to stand, and I think that's more based on the nuance of Ontario legislation to indicate that, yes, an owner can also be an employer if it has workers on site, but there was subsequent questions relating to due diligence which arose. So after the matter went through to the Supreme Court of Canada, the SCC kicked it back to the trial court to actually engage in the analysis of due diligence and whether the city, as owner was duly diligent in the circumstances. And what had happened was the matter was heard. There was an application for leave to appeal afterwards, but in the trial decision, there was a finding that the city had indeed exercised due diligence. And so that's the important component here. There's some good takeaways for owners of construction projects in that trial decision. And the subsequent matter was appealed to the Ontario Court of Appeal, or at least there was a request, and the Ontario Court of Appeal denied it. So this long saga relating to the city of Sudbury is now over, but not without some important takeaways for responsibility and due diligence in the circumstances. So maybe I'll just give you a couple of the highlights and markers of diligence in this case. The city had followed a tendering process. They had previously completed 40 projects with this particular contractor over 5 years. So there was a history there, and that was an element of diligence. They had employed their own workers on site to supervise and monitor that work. That was another element of diligence. They had paid a premium for the expertise that Interpaving was providing. In addition to that, they had previously alerted Interpaving that there was an issue with their fencing and their signage. They had engaged in specialized training, and they regularly participated in meetings at the work site relating to progress and compliance. So ultimately, the court said that those elements constituted diligence in the circumstance. So notwithstanding the fact that Sudbury had been charged, it was the owner/employer and delegated prime contractor, it had exercised due diligence in the circumstance. So a nice case in some respects for employers, notwithstanding the fact that the Supreme Court of Canada has to some degree expanded the concept of potential liability for those in the owner position. Another case is Brant Industries. This is a matter that I will talk about. I am involved in it, and the matter is under appeal, but I thought it important enough to mention to you. It's a publicly reported decision, so I'll talk a bit about this. In this case, the worker had been operating a forklift. He was nearing the end of his shift, which was a 12-hour shift, and he was working the night shift. He was backing out from an area after he had put a pallet down and sought to reverse into another part of the plant. He had reflexively, as he reversed, saw a pole in the back as he was coming back. He had looked at his area and just reflexively put his foot out the back of the forklift and made contact with the pole, injuring his foot. On the stand, he gave evidence that, look, no amount of training would have prevented the incident from happening. It was a reflexive reaction because I saw the pole coming and I just stuck my foot out to try and stop the forklift. That's what he said. He did indicate as well that there was some level of mental distraction. He was hours away from heading out on a hunting trip, may not have been paying attention, and there was a bit of fatigue. So ultimately, the entity gets charged with 2 offenses, one relating to information, training, instruction, and supervision, which is a commonplace charge in this province, failing to provide that. And they also got charged with failing to ensure that a competent operator is permitted to operate powered mobile equipment. In this case, the individual who was injured had previous training at a previous employer, according to the facts of the case, more than 3 years prior to that, and had some considerable experience there, took a break and then began with Brant later in 2020, so 2017 to 2020. And there's some question over whether that training had expired, whether it actually maintained and carried through. Ultimately, the court finds Brant not guilty on count 1. The Crown had not been able to prove that Brant did not provide information, training, instruction, and supervision to workers and exercised due diligence in that context. But the court indicated that as a result of the situation where the worker had come in, and I can explain some of those facts relating to the information he provided the employer in a second, that they were going to find Brant guilty of the second count, which is the operation count and competency count relating to forklift operation. This is something that would probably impact everyone who's listening to this presentation on a routine basis. The court basically indicated that Brant, through its safety program, had engaged in requisite amount of information, training, instruction, and supervision. There was information on the forklifts relating to the non-operation of it by those who are not competent. there were toolbox talks that took place every day, which included, not every day, but every week, and many shifts, which included information pertaining to forklift safety and accident prevention, which the worker in question acknowledged. In this situation, although there was no written hazard assessment for the work, it was routine work, and the worker indicated that they had engaged in dynamic hazard assessments on the job all the time. So they were constantly looking at their surroundings, but for this lapse at the end of the shift. So ultimately, the court said Brandt provided a significant amount of information to workers through its orientation, through the toolbox talks, through the other training sessions that it provided to its workers. It made the information available, plus the forklift itself had information on it about the appropriateness of whether to operate and how to operate and to keep your hands and feet inside the vehicle at all times, that was sufficient. Where the court indicated that there was an issue was with respect to the provision of information about the worker's competency. On his resume, he had indicated that he had forklift training and experience, and he had also represented that he had been certified. He goes through the first component of his job in the first month, doesn't have to operate a forklift, gets promoted to another component, starts working the night shift, and ultimately ends up using a forklift for components of his job. He's got a supervisor who was present, though the supervisor wasn't necessarily the trainer. According to the facts, the supervisor did note that the individual could definitely operate the forklift, had no concerns with the way he operated it, and would have raised those concerns if he saw that there was a problem. So ultimately, there was a question of whether there was some mistake as to whether Brandt was aware whether this individual had training or didn't have training from the previous employer given these circumstances. The court said, given the evidence, given the information between the individuals involved and the plant manager, which interviewed him earlier in the process, there wasn't enough to demonstrate that level of mistake, and there wasn't a training program in place with respect to the training of this individual. So they found Brandt guilty on this count. Now, I note that the decision is under appeal. Further sentencing hasn't concluded, so there is more to come with respect to this. Ultimately, some of the key components that the court put forward in the context of its case that are still important for you are that the court confirmed that due diligence does not require perfection or all conceivable steps to be taken. It simply requires sufficient steps to be taken. In this case, the training information that was provided was sufficient enough. And Brandt wasn't supposed to be held to a standard of absolute safety and second by second supervision in the circumstances. That would be an unnecessarily high standard in the circumstances. Further, it's not necessary that you have formalized and written risk assessments in all cases. In some cases that will be necessary, but not necessary in all cases. And the conveyance of information to workers that they need to constantly assess their surroundings when they're doing routine jobs might be sufficient in some cases. So I think the case is important. Time will tell how this case plays out. It is under appeal, and the sentencing component has not been concluded at this point, so more to come. Another matter involving Brandt Industries, with respect to another case involving a worker who was engaged in one of their plants. They were conducting an inventory count in later in the season, and what had happened was on one of the frames that contained this round type of bar, a bar fell off and contacted a worker. The bars were stationary on the rack. There were stoppers on the rack, and their tasks were simply to measure the bars and count the number of bars on this rack. It was an A-frame style rack with stoppers at the end, similar to what you'd find in other types of steel plants and storage facilities. So during the process of counting, one of the workers was using his measuring tape. They had been provided measuring tapes. They had been provided a forklift as well to remove materials from the racks if they needed to for part of the morning, but for another part of the morning, they didn't have access to it. So they go for coffee, they come back, And after this point in time, they're working on the racks and finishing their count. And one of the workers had pulled this measuring tape and the tape gets stuck in the bars. They tried to pry the tape out. They have access to a number of different tapes. Brand supplied them for free. I tried to pull the tape out. The tape wouldn't come out, but the worker was insistent that they would continue to try and pull it out. So ultimately, one of the workers said, "Fine, I'm going to grab a pry bar, which I had brought with me for the purposes of working on this site." It was his own pry bar from his own toolbox, and he attempted to pry this bar, which weighed a significant amount of weight. It was about 600 pounds or so, and the bar fell off the rack because it was stored in a pyramid style and was stationary, but when the pry bar was applied, the bar fell. So there was a question over whether Brandt had provided sufficient information, training, instruction, supervision, ensured a safe workplace with respect to the circumstances here, and all of that led to the charges before the court. Ultimately, the court indicated that in the circumstances, Brandt had engaged in its due diligence process. They had engaged in the regular realm of toolbox and safety talks. They had not one but two supervisors on site. They had provided forklifts, and the workers could have waited for a forklift if they needed to. The bars themselves were stationary and were not moving until someone decided to take the strange measure of applying the pry bar to one of the bars in order to remove the tape, the measuring tape, which was stuck there, when they could have just retrieved another tape. Interestingly, in this case, there was body cam footage from one of the officers who came out to the accident scene after it had been reported. You see that the officer is standing right next to the area where the worker was with no risk. They hadn't performed a job hazard assessment prior to moving close to this rack and A-frame, and they didn't express any concerns. And so ultimately the court concluded that there was no liability in this case whatsoever, that there was sufficient training, sufficient information. All the workers who had been performing the count were very seasoned workers. They had experience doing inventory and they had conducted the same type of count before. So just goes to show that in some circumstances, you've got experience and you've got appropriate processes in place, and you supply what might be basic materials that the workers could use, that an action on the part of one worker may not necessarily give rise to liability on the part of the employer. So again, I think another important case for employers in the province. Then we get to Sask Power. So this was a tragic accident, and I'm sure many of you have heard about it, but it's a poignant case, and I think an important one to consider. Two workers who were fatally injured after falling from a bucket truck 15 feet above the ground. And ultimately, they were in a raised bucket truck tying in power line. The bucket truck itself, the bucket tipped, and the workers fell to the ground, and both were killed as a result. Both were 19-year experienced journey persons. However, neither had the safety belt lanyards anchored to the D-ring in the bucket at the time that the bucket tipped over. And what had been concluded by the facts was that there was a broken bolt in the arm of the bucket elbow. Now, that's likely the contributing cause that led to the bucket to tip, and then you have the workers who were not strapped in or tied into the D-ring. What I find very interesting about this case, and rather unfortunate, is the workers were wearing their lanyards and simply hadn't tied on. So the court caught on to that, and Sask Power was charged with 4 different types of offenses. Firstly, the general duty count of providing and maintaining plant systems of working environments insofar as reasonably practicable to ensure health and safety. Failing to provide information, training, instruction, supervision that's necessary to protect the health and safety of worker. Those 2 counts are charged frequently in this province, and they can be difficult to overcome because they, in some respects, require you to provide significant evidence of safety in your safety program. The third piece was requiring or permitting a worker to be raised or lowered by an aerial device held in an elevated position unless the worker is provided and is required to use a personal fall arrest system. And then there was a training count. So these workers were very well trained. they had been given considerable training. In fact, they trained other workers as well. So the court acquitted SaskPower on that count, but found SaskPower guilty on the other 3. What the court concluded was generally the supervisor was there. There was a designated supervisor. He was the acting supervisor in the circumstances. The actual supervisor of the crew was located in a different geographic area. I think they were in Weyburn. But the acting supervisor had the ability to review what these workers were doing. They were going up and down in the bucket, and he indicated that he could not see that the workers had not clipped in. The court basically tacked onto this, indicated that the supervisor, when the workers were close to the ground, probably could have seen. And I don't think that the court found that acting supervisor's evidence credible. In addition to that, the court pointed to the fact that there was no system in place that ensured workers were clipped in when the workers were in the bucket. Now, I'm confident there would have been evidence of the requirements to clip in when you were in the bucket from an administrative perspective. However, evidence before the court indicated that SaskPower had changed its process following the incident, and the court relied on that change, I think, in some respects to indicate that there wasn't due diligence before the accident. Whether that's a permissible step or not is open to question. This matter is in the process of being appealed. And so that might be one of the questions that arises, is whether you can take post-accident improvements and apply them to the question of whether you were diligent before the incident. It's been an interesting issue in Saskatchewan over the past few years. It creates considerable uncertainty for employers, but it's one of the issues in this case. Suffice to say, the court found that there was an evidence of a lax environment here, no system, a lack of supervision that contributed to the incident, and as a result found SaskPower guilty on the 3 counts. A couple of other interesting features. No mechanics were called regarding this bucket tilt. The workers were aware that the bucket tilted and they had to manually maneuver it so that it was horizontal with the ground. And they were aware of that. There was also some evidence of an expert that actually didn't make it in front of the court, but kind of did. And so some nuance there that I think might be explored by the Court of Appeal. Ultimately, the court concludes that SaskPower's approach here with respect to inspection, maintenance, with respect to the bucket tilt, with respect to the workers tying in, created the required elements to demonstrate that there was sufficient proof beyond a reasonable doubt that they had failed in the context of those 3 charges. And so SaskPower was convicted. A couple of other pieces here that you might want to know about from the case. The court in this instance grouped this general duty count of information, instruction, and training and supervision, which contains really 4 different concepts, into 2 different buckets. So information, instruction, and training, that's one bucket. Supervision, that's a separate bucket. Although SaskPower had provided information, instruction, and training to the workers on all of the required elements that were necessary to ensure their safety, the supervision component was lacking. And so that was an important piece for this judge in finding that SaskPower was liable. Further, there was comments on the Sudbury case, and the court took that into consideration and just indicated that with respect to general duty counts, in this province, there are overlapping responsibilities on all parties in a workplace, including workers, to take steps to ensure that they maintain and ensure their own safety. And that's present and available. But ultimately, the court looks at Sudbury and says, okay, we have a reasonably practicable standard in Saskatchewan. What does that mean for the Sudbury decision in the context of the belts and braces approach? And the issue in Sudbury where the court had said that the employer is practically the insurer of workplace safety. The court wouldn't go that far in this province. The court would say that the requirement here is to ensure that the employers make the workplace safety, but that's subject to a reasonably practicable standard in the circumstances. So ultimately, there's going to be some level of nuance there for the employer to rely on employees to do their job after they've been trained, or to rely on supervisors to execute the duties that they're required to execute in the context of workplace safety to ensure safety circumstances. So ultimately, the employer is not going to be held to the standard of an insurer, but they're still going to be held to a high standard. It's a strict duty. And that was echoed in the Brandt decision that I discussed earlier, where the court indicated that as well. It's a question of making certain situations and certain safety components. So there are some interesting considerations here about the actual duties of employers that I think are important for you overall. And Sudbury, although it exists, is tempered in Saskatchewan by some of these comments and our reasonably practicable standard, at least according to Sask Power. So what happened in terms of the penalty? Because you might be concerned or interested about that. Sask Power is a larger organization. It's a large Crown corporation. And they were convicted of these 3 counts. The court looked at the sentencing regime, indicated the maximum penalty is $1.5 million. And there's a surcharge that's imposed on that. Court looked at the Crown's ability to pay, and there was a long history of diligence, but there were some prior contraventions, and the court noted that I think there was 21 prior contraventions that were taken into consideration in this case. So some of you may have heard me speak before about the efficacy of appealing notices of contravention when you receive them, for this exact reason, that in a sentencing decision, the court's going to take that into consideration and look at your compliance history. So that's important for you to look at. The court paid attention to it here and noted that there was a past history of non-compliance, and it would have increased the fine, so to speak, because it's one of the factors. The court also looked at this and said there's a high degree of culpability with a small element of contributory negligence on the part of the workers. So Sask Power didn't have a system in place, but yes, the workers didn't clip in themselves, and they probably knew they should have, given the training they had received. So the total fine imposed as a result of all 3 of these penalties was $840,000. So for a single instance of non-compliance where there are 3 different counts that the employer was convicted on, this is the highest penalty that's been levied in the province to date. I find it interesting when I look at this because Sask Power is a Crown corporation. So what you really have is money going from the Crown back to the Crown, to the General Revenue Fund in many respects. And so you've got one hand paying the other. And the court looked at that. They said, yes, that's a factor to take into consideration. But at the same time, this Crown needs to set an example for other Crowns and other industry players, and therefore the magnitude of the fine needs to reflect that as well. So it needs to demonstrate some level of deterrence and responsibility. But the court did for sure take into consideration the fact that this is a Crown simply paying the Crown. So we'll see whether that is reflected in additional jurisprudence if there are other Crown corporations or municipal entities that are required to pay into the General Revenue Fund after a conviction. A busy year for Sask Power. So I should mention that that case, as I indicated, I want to reiterate, is under appeal. So it remains to be determined whether the penalty is going to be appropriate and whether the decisions on liability are appropriate. But for now, that's where we stand. Sask Power had another issue relating to an electrical event. One of the individuals who was brought up to a site in the north part of the province at a hydroelectrical station, they were assessing scaffolding requirements. So they were a contractor to Sask Power, and they were asked to assess scaffolding requirements for this transformer area. The supervisor who was there indicated to the individuals who came on site, look, the unit's alive, don't touch anything, and then simply left them to do what they needed to do with respect to their scaffolding estimate. While they were in the process of dealing with the scaffolding estimate, they utilized a tape measure, and the tape measure, I think, got too close to one of the live lines. And although it didn't touch the live line, I think the evidence was, it arced, and it caused an electrical contact with the worker and significant burns to the worker's bodies. And he was seriously injured as a result. I think the estimate was that there was 60% of his body was burned as a result of this. The real issue, as Sask Power ended up pleading guilty, and ultimately the court looked at this and said there are significant issues of the supervisor who left inexperienced workers alone and not informing the workers of what a safe distance from an electrical conductor was. Here was the finding. This is what Sask Power pled guilty to. 3-16 of the OHS regulations. So failing to ensure that unqualified electrical workers kept the minimum distance from an electrical conductor. What did the court consider? The court considered that the organization, again, is large and sophisticated business with many customers in the province, and the employee count for this employer was, at the time, 3,800 or so. So fairly significant employer. While the offense wasn't motivated by any type of profit motivation, there was a significant level of gravity to the offense, and the injuries were, as the court described them, horrendous. So the culpability here was fairly high. 21 notices of contravention is what the court noted, and plus these 2 prior convictions. So in the context of this particular case, SaskPower, made a number of improvements as a result of the previous matter and this one, but the court determined that the total fine was $700,000 in the circumstances. I must say that is the highest penalty for a singular instance of a serious injury in the province to date, $700,000. Although there's been combined fines that are higher in total, one of those being the Evraz decision, where some of you might have heard of a $975,000 penalty. That was comprised of 2 separate incidents in two different cases. This is a $700,000 penalty. That is not chump change. That is a very significant indication of responsibility and a very significant sum of money for an employer to have to pay. Let's get into some of the criminal liability and occupational health and safety issues for supervisors. There's an obligation under our statute for supervisors to protect the health and safety of workers, to ensure that the legislation is followed, to advise workers of what might be reasonably foreseeable work hazards, and to ensure that workers under their supervision aren't subjected to any sort of harassment or violence. In this context, supervisors can certainly be subjected to penalties if they fail in this type of an obligation. That's under occupational health and safety legislation generally. In addition to that, I'd be remiss if I didn't tell you that there was also obligations on the part of both employers and supervisors with respect to their obligations under the criminal code to ensure that they take steps to ensure that they don't injure another person while at work. This is the criminal negligence provision that protects against bodily harm and bodily injury in many contexts. And it arose from the Westray mine disaster, where there was a number of miners who were injured, and ultimately prosecutions were levied against the owners and the managers of the mining entity, but no prosecution could continue because the legislation wasn't sufficient enough for them to actually create the conviction in the circumstances. So the legislature and the parliament decided they were going to create this separate duty under the code. And this exists. So whoever has authority to direct how another person does work is under a legal duty to take reasonable steps. That would be most supervisors in many situations. So I raised that. It's a reminder. We will talk about a couple of criminal negligence cases in a moment, but I want to talk about Volker-Steven first. This is an Alberta case involving liability on the part of both the employer, Volker-Steven, and Michael O'Neill, the supervisor. Here, I think it's a good example of supervisory liability, and it could happen to any one of you who are on any type of work site. The employee was struck by a truck that was driven by his supervisor while he was on duty. So what they were out doing, they were inspecting catch basins and storm drains. They had already been to this area, so there wasn't much work to do, and there was 2 of them in this truck. The supervisor was working with the employee. He pulls into the area where he's going to engage in the work. He ends up sort of straddling the driveway of the homeowner that he was in front of and the area where the catch basin was. And they parked at an angle to act as a shield from oncoming traffic, as they were trained to do. He was on the phone with another Volker-Steven employee at the time, and there was some level of work. He was on his Bluetooth, so he wasn't holding a device, but he was talking on the phone, and he had the truck parked. So while he's on the phone, the worker exits the vehicle, goes to the back of the truck to grab the tools. At least the court finds that. No one actually saw this happen. Ultimately goes and crouches down by the storm drain, and then the employer, or the supervisor, excuse me, who's in the truck, sees another vehicle coming in. It's the homeowner. He can't get into the driveway because the truck is partially blocking it. And he pulls the truck forward about 2 meters, and you can play the movie forward. Unfortunately, the worker was catastrophically injured as a result and suffered skull injuries as a result of the truck that moved forward in the circumstances. 911's called. The evidence in the case is dramatic in that, you know, someone had found the employer, or excuse me, the supervisor eating snow because his mouth was dry, is what the case indicates. So you can understand the impact this might have had on the supervisor in question. The court finds that, yeah, the supervisor would have known the worker exited the vehicle. He would have known that he was going to do some work, and he would have known that he was probably crouched down, and he didn't end up taking any steps prior to moving the vehicle forward to ascertain where the worker was. He didn't exit the vehicle and do any kind of circle check to determine what was going on, and that was a failure on the part of the supervisor in this context. There was a big debate in this case about victim blaming and issues surrounding worker responsibility. And the defense made the argument that the act begins and ends with workers and their responsibility for personal safety. To some degree, I don't disagree with that proposition, because I do think there's a huge element of personal responsibility that's involved. And you can see it flowing from the SAS Power decision. You can see it flowing into this case and the other cases we talked about with Brandt, where the individual, you know, brought the pry bar and used it and it caused the incident on a perfectly stationary set of bars. But at the same time, the Crown said that the defense is victim blaming here because there was a question of whether the worker who was involved should have taken different steps to ensure his own safety when they're next to a vehicle. The court didn't see it that way. The court basically saw that, and that was the slide that I just referenced, the court basically saw that the supervisor was acting as a supervisor, had significant responsibilities. The matter was reasonably foreseeable, and O'Neill, the supervisor, was distracted by the phone call that he was participating in and that vehicle that was coming that he wanted to move forward for. These distractions, the court said, resulted in O'Neill moving the vehicle without concerning himself with safety generally and the injured worker's safety in particular. The court held that it would have been reasonably practicable for O'Neill to conduct a visual inspection of the worksite set up in front of the vehicle prior to moving the vehicle forward. So as a result, the supervisor was found to be guilty. The court also, the court also found that the supervisor here was moving a piece of powered mobile equipment in a manner that exposed the worker to danger. Several common sense steps, such as ending the call, getting out of the truck to confirm where the worker was, and ensuring that his focus was on the operation of that powered mobile equipment as opposed to that phone call, should have been taken in the circumstances. So there were significant consequences here. Volker Steven was also found responsible as an employer in the circumstances. They were subject to a $480,000 penalty, and the supervisor, though not subject to any criminal liability, was indeed subject to a $66,000 penalty, which is a huge fine for an individual to have to pay as a result of this, but obviously very serious consequences in the circumstances. So we shall see whether there are subsequent cases which reflect the similar type of penalty against supervisors. But this is a good case. It's one of those circumstances that many might know. You might just be distracted, you're talking on your Bluetooth and not necessarily paying attention to your surroundings, and at the end of the day, you might cause an incident. So these types of vehicular issues can happen all the time. So it's a good example of potential risk for supervisors and employers. Gooch is a case I like to talk about. Gooch. It involved a circumstance where the individual was in fact charged with criminal negligence causing death, and he was part of a 3-person crew, and he was the supervisor of this 3-person crew. They were installing weather stripping or blue skin on the walls of a particular structure. And while they were working, one of the workers who was fatally injured was at the top of the site the day prior, no issues. They were strapped in. They understood their environment. They understood where they needed to be. The worker had performed his job without any incident and moved through the process without any issues. And in the context of that first day, no problems. It comes back the second day, the worker's late. That might be an issue. As they're walking backwards, they simply fall off the edge, a leading edge of this structure, and he fell to his death. What the court found was that there was a significant amount of THC in the substance of in the body of the individual who was injured, and that THC would have been a contributing cause. So there was a intervening act which formed a defense to these criminal negligence charges, or at least part of it. Plus, there was reasonable precautions that had been taken in the circumstances. So Gooch was ultimately found not criminally liable in the circumstances. He had met the standard of care, he had performed hazard assessments, and he had ensured that fall protection equipment was available. Similarly, the industry standard was met as well. The regulations explicitly mandated tie-offs when workers maintain a specific distance from a leading edge. There was a work plan designed with the expectation that no worker was going to be working within 6 to 10 feet of the edge of the roof. And that worker had understood that from the day prior, but didn't obviously understand that in this case. But there was this intervening event relating to intoxication that broke any sort of causal link. But that doesn't mean that Gooch couldn't be charged under occupational health and safety legislation in the province. And he ultimately was. So although he was acquitted of the criminal negligence charges, he was ultimately convicted after pleading guilty to occupational health and safety charges in the province. Now, I looked at this. There's no reported decision. It's reported in some of the media reports. So we take with what we can with a grain of salt, but it looks like he was subjected to a $14,000 penalty with an obligation to deliver 8 safety presentations and complete 100 hours of community service. It was a joint submission. He had acknowledged that he failed to ensure that the workers used fall protection on 2 occasions, including the day of the fatal injury. And there was some question about providing false statements to occupational health and safety. Now, that isn't entirely clear from any of the media reports, but interesting type of decision. The important piece here is that you can be charged under both statutes, and there could be liability under both potentially. So you're looking at a variety of different obligations. King is another case. I think I talked about it previously. I just want to give you the conclusion of the case. Here, there was a supervisor who was charged when a worker who was under his supervision was working in a clarifier. There was a large pneumatic plug they were using. They were going to do a flow test and a leak test, but the worker was in this confined space, which is effectively a sump in this large clarifier system, and the pneumatic pump or tube, it leaked and it failed, and then it basically left the pipe and caused the worker who was in this 8-foot sump to get caught in that area because he couldn't be relieved from that particular pneumatic tube. So effectively the tube leaves the piping and then still expands in the 8-foot area, pinning the worker to the side while there's thousands of liters of water flowing and ultimately causing the death of this individual. So King gets charged because there's a number of failures. What had happened was during this leak test, he didn't tell the workers that he was going to actually engage in the leak test and turn the water on. There was no evidence that there was any confined space training or confined space understanding in the circumstances. The supervisor hadn't engaged in any particular type of training under occupational health and safety for supervisors, didn't really know his obligations, and the court lambasted him for that particular failure. There was no safety plan for the worker to extricate them. There's no tripod in case something like this happened. So there was a number of failures. Ultimately, King is charged. The court, like I say, says Mr. King put the injured worker in the hole, then put water into the system. He was the cause of his death. And as a result of this, he failed to meet the reasonable standard expected of a site supervisor. He was sentenced to 3 years in prison. So this is a criminal negligence case, and he subsequently appealed to the New Brunswick Court of Appeal, and the important point here is that that appeal was denied. So the court found 3 years in prison for a supervisor was an appropriate penalty in the circumstances. So these are significant pieces of liability for supervisors who work in similar industries to you. So what are the takeaways? You can be charged and convicted of both OHS related offenses as employers and supervisors, and you can also be charged and convicted of criminal negligence charges under the criminal code. Convictions against supervisors can happen. The consequences can be severe. And in the context of all of this, the courts are going to be assessing all of your safety policies, your procedures, the training that was implemented prior to the incident, and assessing a variety of different things. So I look at this, and ultimately the court's going to take a look at the entire set of circumstances, and the assessment of overall liability will depend on what that supervisor did. Now I see that the King case, there's a question about the King case specifically of whether the employer was charged. Yes, the employer was charged. The employer ended up pleading guilty without proceeding to a trial. At Spring Hill Construction, I think they received a $100,000 penalty. Another question arose, do victims of an incident get any portion of the fines that the companies receive? That's a very interesting question. And it's one that's being subjected to challenge in this province by one employer. There's a victim fine surcharge, and the short answer to the question is no. The short answer is that victims are subjected to the workers' compensation regime, which exists for that purpose. The fines that are levied, a portion goes to the victim fine surcharge, 40% that's tacked on top of this fine goes to the victim fine surcharge, which is a fund. And if you look into it in some detail, you'll see that although it goes to a victim's fund, it actually gets transferred over to the general revenue fund, and there's a loan arrangement there. But anyways, I digress. That is not accessible to workers who are injured in the context of occupational health and safety offenses. It is only eligible to workers who are injured by virtue of some federal criminal code offense like assault or a domestic violence type of issue. So what you have is employers who are paying fines and penalties associated with workplace infractions under occupational health and safety, and the funds that go from that into this other larger pool do not benefit any of the workers who are injured as a result. They're left to the workers' compensation regime, and there's no access for funding. So that is a tricky circumstance, and some would say that that's not necessarily constitutional, and so we'll see whether those challenges are sustained or maintained. Just before, I will answer some of the other questions that have come up in the comments, but I do want to get to this last piece of ladder and scaffold safety. It's an emerging issue, and there has been 2 prosecutions relating to ladder safety, plus a prosecution relating to scaffold safety in the province. So I thought it important to mention to you about these issues. It's a bit of a trend. In Epic, the employer ended up pleading guilty to failing to ensure that a portable ladder was secured against accidental movement during use, resulting in serious injury to a worker. The worker was using a large extension type ladder on the exterior of a home. He was under the 9-foot threshold, but he had placed the ladder on a tarp on the bottom of the ladder, and it wasn't at the right angle. So as a result, the ladder slipped out. The worker jumps off the ladder and ends up injuring his arm. And so when they contacted Occupational Health and Safety and OHS did the investigation, they determined that the ladder wasn't at the right angle and it wasn't necessarily appropriate in the circumstances. So the company ended up entering a plea of guilty. They ultimately saw that there was a $45,000 fine. It was a family-run business. There was a degree of negligence on the worker's part by acting in an unsafe manner. Not necessarily the smallest employer, but not necessarily the largest either, but still a significant penalty for an employer in this context. Adler was an interesting case involving a matter which took place on a reserve. So there was construction activity taking place on a band's reserve, and ultimately there was a scaffolding issue. So the workers were in there, they had erected the scaffold. The scaffold didn't have the appropriate braking system on it. the cross members of the scaffold hadn't been properly installed, and the individual who was running the scaffold, who was a supervisor, acknowledged that there was issues with the way that it had been set up, but he was in a rush to complete work on his own motion, not as a result of the employers. And so he gets on top of the scaffolding, and they were applying type of fire stopping material to the roof, and he's pushing the scaffold forward with his feet using momentum, as opposed to making it stationary, tying off, and then having someone move the scaffold for him, and he ends up falling and hurting himself. So the court and the Crown took significant issue with this. There was a slightly larger company than Epic was, and the underlying system that was in place didn't demonstrate any type of scaffold safety in the circumstances. So given the circumstances, there was a fine of $100,000 in this instance. Now, there are jurisdictional issues when you engage in construction work on what might be federal reserve lands. So that creates an issue, and it's one of the reasons why I wanted to mention this case. So if you are taking activity on a federally regulated property like a reserve, there could be issues that may give rise to an entirely different statutory regime that would apply. In this case, it was OHS in the province of Saskatchewan that applied, giving rise to a fine here of $100,000 in the St. Walburg area. Finally, there's the Saskatchewan Health Authority. And here you had a worker who was working on a facility, a healthcare facility, and they were installing a gazebo effectively on the exterior of the site. They had used a stepladder and had it folded up instead of with the legs extended. They had pushed it up against the side of a structure. It was sideways like this on gravel that was not necessarily horizontal or level ground, and the ladder slipped out. Unfortunately, the worker falls and he injures his torso. In the circumstances, there are instructions on the side of the ladder. The worker was very experienced, and it's not a very complicated piece of equipment to use. However, the underlying failure was there, and the entity, Saskatchewan Health Authority, decided it was going to enter a plea of guilty as a result of failing to ensure that the ladder is used and maintained and performing its function safely. There was no specific ladder safety training provided to this worker, and that led to part of the reason why the entity pled guilty. $75,000 fine, inclusive of that victim surcharge. So the Saskatchewan Health Authority ended up pleading guilty to that. It's a larger employer, and again, another instance of ladder safety. So look at your ladder safety procedures, your policies, ensure that they're included in your safe work procedures or standard operating procedures on how to use them. Perhaps engage in some sort of ladder training refreshment course. That kind of thing might serve you well in the future, given that this is an area of potential review. So just to get to a couple of the questions, one of the questions is, how liable is a company in cases of workplace violence involving contract workers leading to a serious injury or fatality? It's a tricky question to answer. If there are contract workers on site, there might be questions about whether that employer should be liable. What you want to do if you are, say, the prime contractor and you're encountering issues is that you have the appropriate violence and prevention plan in place, that you examine it, you ensure that you roll out the training required to all of your contractors on site, and make sure that they are aware that it's not appropriate to engage in that circumstances. If you have that type of instance of activity, you may want to discipline the parties that are on the site and tell them that type of behavior from that worker specifically will not be tolerated, and therefore that worker or that contractor needs to go. Those are the steps that you can take. It's difficult really to assess how liable the individual or the entity might be, but they could be subjected to responsibility if there's an instance of violence. I'll give you, a recent example is the case that arose in Saskatoon, where you have an unexpected instance of workplace violence. There could be risk associated with something like that. So you definitely need to ensure that you've got the appropriate violence prevention plan in place, because it could give rise to liability under occupational health and safety statutes, and in the worst possible case, criminal negligence. So hopefully that answers the question. And another comment here, there was a comment from one of the participants that there are cases where creative sentencing is applied in Alberta and Saskatchewan. That is a very excellent point. I sure wish in this province there was a creative sentencing regime. And in Alberta, what happens is there's a specific legislative mandate that allows that. Firstly, judges are able to order that type of penalty. So you might pay $1,000 fine and $99,000 to an organization in the province. Usually it's a safety organization just like yours. That's administered by one or two members of occupational health and safety. They help employers who are going through this process navigate that system, and they determine whether there's a reasonable case to be made. You present it to the judge, and the judge says, yes, I like this. It's been sanctioned by OHS. It's a good creative sentence, and it will benefit safety in the community. And so they might sanction those. I've had judges question as to why we wouldn't just give the money to the government in Alberta cases. And in my view, I think that organizations like yours can maybe do it better in a lot of ways. And you touch on the basis of the members that you've got. Your industries perhaps better than someone who's simply working in a government department, and they're going to consult with you anyways. So I see that the funds, applying to safety, doing are very beneficial and restorative in many, many ways from a sentencing perspective. Unfortunately, Saskatchewan does not have a regime like that. There have been very limited instances where some type of creative option can happen. However, it's very few and far between, and it takes the right case. So I wouldn't necessarily say that it's an option in this province. The last question I'll answer is, how often should a company have workers review safe work practices, safe job procedures to establish their due diligence? There is no definitive timeline here. What I would suggest you do is document the fact that they've reviewed it at least once. So, and it also depends on the seriousness of the safe work practice or safe job procedure. So if you've had instances of inappropriate use of powered mobile equipment, for instance, or say fall protection issues have arisen on your work site, it might be appropriate in a everyone gets into a boardroom, you have a PowerPoint presentation, and ultimately there's a training session on it, and workers reiterate the fact that they've been given this training so that there's no issue there. That would be useful for that type of activity. So there's no hard and fast rule, but at least once, and make sure it's documented. I know there's another comment here about the regulations opening up for recommendation or consideration. I do believe that's the case. In discussions with occupational health and safety, I don't believe that there's any fixed date for that. But of course, we wait with I guess you'd say bated breath in terms of determining when that's going to happen. Industry will certainly have a role to play in that consultation process. And it has been a while since the regulations have been reviewed. It sure would be nice if we had a creative sentencing regime in this province, I can tell you that. So that brings me to 9:35. I'm prepared to answer more questions, but I think we've got some timing issues, and you're probably on to the next one. So with that, I'll say thank you very, very much for the opportunity to present to you, and I'm happy to answer any questions you might have offline at any time. You'll be able to reach me, and I really appreciate it. Thank you very much.